I'm Emily. Richard is my law partner. We are criminal defense attorneys primarily. We do some ancillary civil work that sort of gets wrapped in with the criminal cases. Primarily what we do is represent people who have been charged with crimes involving firearms, self-defense. I mean, we're primarily defense attorneys who represent violent crimes, everything from Class C, sort of ticky-tacky misdemeanors all the way up to murder. So, Richard, anything you want to add to our qualification?
No, it's just we've kind of situated ourselves where we have a lot of traffic from the Second Amendment community, whether it be from, we handle almost exclusively self-defense cases. And so, with that, we have lots of people who come and talk to us about, hey, I had to defend myself, and these cases are kind of all or nothing. So we get wrapped into quite a few pro bono cases, and that's what we're going to talk to y'all about today.
All right. So we're going to talk a little bit about where to find pro bono criminal work. Then we'll go through, we'll spend most of our time with a practical overview of this is how you get started. If you are either not very experienced with criminal cases or have never taken one before, we'll talk through navigating the Harris County system, the jail, the courthouse. Those are your practical considerations. And then we'll have time at the end for question and answer. So I'll go ahead and start here. So why pro bono? I'm glad that you guys are interested. Maybe I know that Hyla, or I understand that Hyla is publishing a list of people who want to volunteer for protesters who have been arrested recently. It is not only a good thing to do for your community, it's actually mandated by the Texas Disciplinary Rules of Professional Conduct that you should be taking pro bono work regardless of who you are, what you do, how busy your practice is. It is a really important part of what we do here in the community. For criminal defense pro bono work, it's actually, I think, especially gratifying because we're not talking about, this is someone suing someone else over a contract dispute. I mean, this is keeping people out of prison, potentially. It's keeping them with a clean record so that they can get jobs. And, if you're interested in racial justice work with everything that's going on right now, it's a great place to volunteer, to really dig your hands in and get going with maybe putting yourself into our current state of affairs. There's not a single criminal defense attorney in the whole city who will tell you they have not seen clients investigated because of their race, arrested or disbelieved by police because of their race. It comes into effect with the way that prosecutors and judges, maybe even unintentionally, bias themselves against. So it is, it's a good thing right now, and it is not easy to find pro bono criminal work. So go ahead, Richard.
I'll jump in real fast. And Emily likes to say this a lot. The government is a bully when it comes to criminal cases. And so it's very rewarding to be the person standing up to, everybody likes to watch that video on YouTube of some bully getting his ass handed to him, and that's what this is. Comes up a lot of times because the government's a bully when it comes to criminal work. They railroad people, and so it's nice to be on the side of defending the little guy. There's only one branch of government that's devoted to equality, and that's the judicial branch, and that all relies on, public trust, rule of law, and accessibility, and it's not accessible to a lot of people, and that's why pro bono work, I think, is really important.
Yeah, absolutely. It is. Of course, this is the area of law where if you can't afford an attorney, you're entitled to one. Everything from Class B misdemeanors upwards. So there aren't a lot of organizations that help organize pro bono criminal work because you have this sort of built-in network of free attorneys, but there are varying degrees of free attorneys. When you actually go through and you're indigent and you have to apply for court-appointed attorney or a public defender, sometimes you hit the jackpot, and that's great. And sometimes you have a court-appointed attorney who doesn't care and is just pushing you through the system to get their paycheck. And so it is a good thing to be able to reach out to find these cases. The Texas Civil Rights Project is a great place to sort of figure out where to find pro bono work. But really the best way is organically. You know, you hear of something that's happened. You know, just a recent example, I have a girlfriend who lives in League City who she was trying to organize a march for the Black Lives Matter movement, and the League City Police Department actually threatened to arrest her. And so that was a case that I would have taken on pro bono had they actually gone through with their threat. So organic is great. And in fact, although I know that it's drilled into us, Richard, or someone who's a host, can you mute wherever the noise is coming from?
Yeah, it's Allie, can you handle that? All right, it looks like it's stopped. Oh, Emily, now you're muted.
Okay. It's drilled into us. You cannot solicit clients. You can't, call someone and reach out and try to get them to hire you when you know that they've been involved in some sort of incident. But Richard, do you want to explain the nuance to that? Because if you're not working for pecuniary gain, you have a little bit more freedom.
Yeah, well, and Emily just summed it up. So the idea behind approaching somebody, so we're talking about organically, I don't know if you're in a fraternal organization or you're part of some club or, your kid's soccer team or somebody just in your neighborhood. If somebody were to be arrested for a crime and, you just thought, hey, it's the right thing to do, this person shouldn't have to take out a second mortgage to protect themselves, I want to help them. It's not against the rules to approach them and say, hey, I'll represent you. What is against the rules under the rules of solicitation under the Texas Rules of Professional Responsibility 1.07 is your significant motivation can't be pecuniary gain. And so you have to think about it. Am I doing this for the right reason? Am I doing this for the best interest of the client? And if the answers to those questions are yes, then, I think you're going to be in a good spot. What may not be okay, and unfortunately I don't have any guidance. We don't have any comments that give us any guidance on this, but you see some high profile case, it's all over the news. If you're thinking, hey man, I bet you I can, boost my reputation. I bet you I can raise my notoriety. If that's the reason why you're taking the case, that's not the right reason, because behind that is a significant interest of pecuniary gain. That's not the right pro bono case for you. So really, the interest should be in the client and not directed towards yourself.
Exactly. So, if you're thinking, gosh, I heard about this case, or I've got this friend of a friend, and, I want to reach out, volunteer my services for free, just make sure that your motivation is not pecuniary gain, is not building your practice, is not building your profile. It's actually, goodness of your heart. I want to help someone. Okay. Richard, how do you find someone in the jail?
All right. Well, the bare minimum.
It's step one.
Yes, correct. And our targeted audience is people who've never had a criminal case before. So if you practice any criminal law, this is going to seem very rudimentary. But the minimum information you need to locate somebody in any jail is their name, date of birth, and county of arrest. With those pieces of information, you can track down pretty much anybody in the state of Texas. And so for Harris County, they have a Find Someone on Jail. It's regularly updated. There is a little bit of a delay. I practice more in smaller counties. I primarily practice in Galveston, but I do things in Montgomery and Fort Bend and Brazoria. They don't have as sophisticated jail inmate systems, or at least they're not as updated as frequently as Harris County. Harris County is pretty user friendly. But worst case scenario, if it's not in Harris County, you see that Find Somebody in Jail, you can do it the old fashioned way. Just call the county jail, be polite. Hey, I'm an attorney. I want to see if I have a client in custody. Here's their name, date of birth, what are they charged with? And you'll find, you'll get a lot of answers with just that basic information and a kind disposition.
Yeah, and we're going to be talking through Harris County for most of this presentation, not only because we're in Houston, but because it is the most complex, confusing, intimidating system in the region, maybe the state. So we're going to talk through that. But if you have any specific questions about other counties, You can ask during question and answer, or we're going to list our email at the end of the presentation. If you decide you want to take a case in Montgomery County and you have questions, shoot us an email. We'll talk you through any specifics in the rest of the counties, but they are all easier to navigate than Harris County, which is why we're going with this. So this is how you look someone up on the jail website. You have really, it works pretty well. You can put in a partial last name and you're going to pull up a ton of people, but you're probably going to find who you're looking for. If your client has a very, very, very common last name, or, you know, maybe first and last name, you got a John Smith, you are going to want that date of birth. You're going to want to know, you know, his charge, things like that to find him. But this is the screen you're going to encounter on the inmate search. Like Richard said, you know, it gets updated sometimes up to 12 hours after arrest. It just depends, but people are not immediately logged into this system. It takes a little bit to process them in. And
I'll add on to that before we get the spins and things like that, Emily. Another important resource for everyone here, if you're not already, create a login for the Harris County District Clerk's website. When people are magistrated and processed in, that information is posted simultaneously at the district clerk's in the district clerk screen. So you can get a lot of the same information. You'll get some different information, but you'll get a lot of the same information there. It lags a little bit further behind this system, but that's just another resource at your disposal.
Yes, absolutely. So we're looking now at what you would find when you search your client's name. I just did a random search for, you know, Miss Keisha Knight popped up. I do not know anything about her case. She's not a client of our law firm. This is just the random search I did and she popped up. So you are going to want to know your client's SPIN number. That is incredibly important to actually making a jail visit and speaking to them. It's how the county identifies them, is by SPIN. Now you're also going to need this very important piece of information, which is their jail location and their pod number. So before you even get to the jail, I recommend looking this stuff up. Look at it the morning before you go, find the SPIN, know their full name, know their pod number and their location. There is a way to look it up once you get to the jail, but it is a gigantic book that 1 million people touch every day, which was unpleasant in January and is killer now. You do not want to touch that book. So have the information ready. You'll fill out an attorney slip. You'll bring your bar card, your driver's license, and you will need that information, their SPIN, the jail location, and their pod number. And here are the jail locations. So I'm going to go back. You see Miss Knight is in JA09. Here we go. So JA09 is what we call Big Baker. There are many, many Harris County jail facilities. You just need to look, make sure you're going to the right address, or else they're going to send you on a very hot walk down the block in July heat to get to the correct location. Richard.
Yeah, so when you're visiting somebody in jail, there are a few crucial items that you should have: your bar card, your client's location ahead of time, SPIN number, and you need to bring a book because you can expect to wait a very, very long time in Harris County. You'll go in, identify yourself, sign in, and the waiting begins there. You'll be moved, you know, they're going to move you around a couple of times. You might be on a different floor. It just depends. What I will add to this also is the procedures are changing very rapidly due to the coronavirus. So I would recommend that you check ahead of time. They are posting regular updates on the Harris County jail website about visitation procedures. You know, visitation for attorneys is not the same as visitation for lay people. You know, when you see visitation hours, don't feel like you're confined to every other, you know, day on odd weeks, you know, depending on what their last name is. That doesn't apply to you. There are some limitations when you do visit some people. You know, if they are in a medical facility, if they are on lockdown because they're suicidal, there could be a couple of reasons why you couldn't visit your inmate. Don't do it at 2 a.m. in the morning. The jailers are going to hate you unless it's necessary. Sometimes that's what you got to do. But just be prepared ahead of time. And that's really all I have. Emily, do you have anything to add on to that?
No, it is important to know you are not confined by those hours on the website. You are confined by your inmate, your client being in processing. You'll see that designated PROC. If they are in processing, attorneys cannot get to them. Sometimes, we've had clients be in processing in Harris County for 24 hours. So when, their family's calling you saying, why can't you get there? The answer has to be, I'll be there as soon as they're out of processing, but there's no way for me to get there. Now, hopefully, your first step after you find them in the jail is to help them get out. We have a bail bond system, and essentially that is just, your bail is just your promise to appear. You're putting up money saying, this is essentially my collateral that ensures that I'm going to show up to court. In a perfect world where bails were set at reasonable amounts, people would be able to put their whole cash bail up. I would be, required to pay, $200. My bail's $200. I'll put my $200 down. Once my case is resolved, all that money comes back to me. Realistically, bails are set at $20,000, $30,000, $40,000, which people just cannot afford to put down. So that's what a bail bondsman is there for. The bail bondsman takes a percentage, generally about 10%, from the surety, from the person who is going to promise to appear or the person who is co-signing on their behalf. They put up the rest of the money, and then you don't get that money back that you've given a bail bondsman. So unfortunately, not as good as making sure you make it to court, getting all your cash back, but it is a way to get out of jail.
Yeah, and what I'll add is, before a bond is set, even if you had $1 million cash on hand, you're not going to get your client out of jail until they have their bond set. In Texas, people who have been arrested are required to be magistrated within 48 hours. It happens a lot faster in Harris County. They are doing it all day, every day, to the tune about, every 4 to 6 hours. If somebody's been arrested in the previous 4 to 6 hours, they can expect to be magistrated. Most counties, not Harris County, because Harris County is a mega city. Magistrate takes place the next morning, typically in the morning, so almost always within 24 hours. But until that bail bond is set or that bail amount is set, they won't be able to get out of jail. Tim, do you want to talk about bond conditions?
I do. So another thing to know, because clients will ask you what they can do when they are on bond. And all of the answers live in their order that lays out their bond conditions. Judges can impose virtually any condition on bond that would, I don't have the exact language on the tip of my tongue, but it's something to the effect of, anything reasonably related to the protection of the community.
It's reasonably related.
So there's almost, yeah, there's almost nothing they can't do. Your client is going to be subject to random urinalysis. So it's incredibly important to make sure they know no use of any sort of drug that they don't have a prescription for. No drinking. They will test generally for alcohol in urine as well. And you do not know when they're going to be tested, except if it's a felony case, they're most assured to be tested at their first court date. They are going to have to probably remain in the state of Texas. There are all sorts of conditions depending on the case, including if there's a victim in your case, they're going to be ordered to stay away from said victim. So what can go into their bond conditions, virtually anything. Make sure that you're checking that document before you advise them what they can or cannot do. And if there's something that is untenable, for example, I've had to go argue the client had to leave the state of Texas. I've had to go argue the client had to be able to, get to the home of the victim because it happens to be their home, a family member's home, things of that nature. You just have to go in, make your arguments, cross your fingers, see if they will alter the bond conditions. But Harris County is not often amenable to altering bond conditions unless there is a true emergency situation.
And what I'll add to that, I would say most of the bond conditions are things that we all normally do. You know, don't commit crime, don't do drugs, pay your child support, things like that. Raise your dependents. It's all stuff that we all already normally do. Be very careful with alcohol-related offenses or offenses where they think that your person may flee the jurisdiction. There are some add-ons to bonds that can be, or bond conditions that can be extremely expensive to your client. A scram device can cost $300 a month. One of those devices you blow into, the interlock devices that you have to blow into to start your car. Those can be between $50 and $100 a month. And so this stuff really adds up. I mean, I don't have a subscription to anything that costs $300 a month. And if you're representing somebody pro bono, they probably don't have that kind of money. So like Emily said, if you can, try to seek to make these conditions less odious on your clients.
So clients get their bonds revoked for various reasons. Anything they violate on that bond conditions could get them thrown back into jail. They can also forfeit their bond by not appearing, or, which is really relevant in Harris County, by being late. Judges in most counties will give you a break for being late. Harris County judges are notorious for tossing people back in jail for just, being 10 minutes, 15 minutes late to court. So you can see here, there is a process for bond forfeiture. They call your name in the hallway. There is very little that will get you out of a bond forfeiture for not showing up to court. You can see, thank you, criminal code of procedure, the death of your client, their bond will be forfeited, which is lovely. And then, very reasonable. And then you can see in subsection 3 there, it has to be an uncontrollable circumstance where they had no fault in why they couldn't get there, a car accident on the way, they're hospitalized, whatever had to be, it was really, really an emergency. Make sure that when your client's name is called and they are not there, that you're ready to argue one of those causes which will exonerate. And if you don't know why they're there, you just need to beg. Occasionally judges will take pity on you. You say, Judge, I spoke to them last night. They know they're supposed to be here. They assured me they would be here. Would you hold and let me try to track them down? Some judges will be kind to you, some will not. But sometimes the only thing you can do is beg.
Yeah, and I'd say the 3 most common reasons that a bond is forfeited: dirty urinalysis, because they're using controlled substances; failure to appear. Your clients, especially in Harris County, need to show up extremely early. As attorneys, we can zip to the front of the line. We can zip up to the elevator. In Harris County, in the criminal courthouse, they are down. There's always an elevator that is out of order. It's just going to happen. Compounded with coronavirus, they're only letting 4 people on the elevator at a time. And they're trying to cycle in several thousand people to 18 different floors in a couple of hours. So it's a real nightmare for your clients. Advise them to show up an hour early. We don't want them to get in trouble for failure to appear. Now, I'd say the last most common reason people would lose their bond is new law violation. If you find yourself in this situation, you just have to be an advocate. The bond is not supposed to be there to punish people. It's supposed to secure their appearance at trial. And the second part is that they're not a danger to the community. So when you're making your arguments, the things you're focusing on is they're going to show up. It's hard to argue that when they didn't show up, but ties to the community, that they have a job here, that they don't intend on living out of state, they don't have family out of state. Those are things that would tend to show, hey, look, they're gonna show up at trial, and then not a danger to the community. That's stuff you just have to think about. Is this a theft charge? Is this a violent crime? Are they likely to repeat? Do they have any criminal history? Those are the things that you need to be advocating for when saying, hey, look, they're going to show up to trial and they're not a danger to the community. Those are the 2 things that judges are going to be focused on.
Yeah. Okay, so you have visited your client in the jail, you've gotten them a bond. Let's hope now you have to actually get the case resolved. So criminal cases are resolved in a number of different ways, in, I suppose, order of of importance, or your best wish first, we can resolve them by declination, by no bill, by dismissal, plea bargain, or trial. And we're going to go through each one of these in turn. So Richard, do you want to talk about decline charges?
Yeah, so decline, y'all won't see that very much in Harris County, but you just have to know that's an option that exists. A decline is whenever, the police think there's probable cause to make an arrest, but then whenever a district attorney reviews it or an assistant district attorney reviews it, they don't think probable cause exists. So they make the decision, hey, you know what, this case shouldn't go any further. Why you don't see that in Harris County, they have on-call DAs for felonies and misdemeanors. And so a DA has already pre-screened this case and said, hey, I think probable cause exists. So you don't see a lot of declines in Harris County unless a new piece of evidence comes out. Let's say surveillance completely exonerates your client. I had one of those. That's when you would see new evidence coming forward in Harris County. In other counties, if they don't have an on-call system, then you may see more declines and you can start advocating earlier. Do you want to talk about no bills, Emily?
Yes. So on the felony level, you are entitled to an indictment by a grand jury. There is no indictment for misdemeanor cases. Misdemeanor cases are filed by information and complaint, whereas your felony cases, you are entitled to have that indicted by the grand jury. You only need 9 grand jurors of 12 to issue what's called a true bill, which is your indictment. And you actually have the option of waiving indictment and just letting the state proceed forward based on the charging instrument, which is the information alone. That is almost never a good idea. You always want to give that, take that extra bite at the apple with the grand jury process. The only situations in which you might want to waive indictment would be, your client's not out on bond, they're sitting in jail. They have admitted to you, that they were caught red-handed. You've seen enough evidence to know that there's not some sort of crazy suppression issue or something that's going to make it go away. And the state is offering, time served and your client can plea and get out. That is the rarest of rare circumstances. When it really comes down to it, there are very few situations where you're going to find that it's actually a good idea to waive indictment. Now, that being said, you want your case to go to the grand jury. As a defense attorney, you have no right to be in that grand jury room. It's a secret proceeding. All of your advocacy has to be done in writing in a grand jury packet, which we'll talk about in just a moment. Grand jury packets are generally worth it. You want to try to get those grand jurors to believe that there is not probable cause that your client committed the offense. They are a double-edged sword because you are showing your hand to the state. You're essentially saying this is our theory of the case. At the same time, there's no rules of evidence. So there's lots you can do with the grand jury packet. And you are, even though it is almost always fruitless, it is a good idea. Richard and I both were prosecutors in Galveston. Richard swears that he could get 10 cases indicted in 5 minutes as a prosecutor.
No, the standards are very low. Yeah, the standards are very low. I mean, they don't pull in witnesses. They don't, sometimes they will on bigger cases, but most of the time it's just a prosecutor reading an offense report to grand jurors. And at that point, it's, do they believe what the prosecutor's saying at that point? Some prosecutors, and at that point, and there was a big push for grand jury reform this last legislative session. We didn't see any of it, but there is a big push because prosecutors don't have to talk about favorable evidence. They don't have to talk about evidence that exonerates the alleged defendant. While I think that would be the right thing to do and the ethical thing to do, they're not required to do that. And so they'll get a very one-sided view of the case. And if you can poke any holes of doubt in it, then it's a really good place to go. And that takes us perfectly into grand jury packets.
Yes.
Oh, dismissals? Oh, dang. All right. We'll talk about dismissals.
And then go into the packets.
Okay. Do you want to talk about dismissals?
Dismissal. So, yeah, just quickly, it is at the discretion of the prosecutor. So clients who have watched a lot of true crime, you know, a lot of Law and Order, are going to say, ask the judge to dismiss it. And unfortunately, that's just not how it works. It's more of a beg the prosecutor to dismiss it. And it is easier in some counties than others, even to get a case that really deserves dismissal, to actually get the prosecutor to make that happen. So oftentimes dismissals are conditional. You know, Richard is listed here, 8 hours of community service plus a clean UA. That was a very typical dismissal in Galveston back in the day. So there's lots of things they could condition a dismissal on. There are two ways to get a case dismissed, primary ways. One is what we call a straight dismissal, which is even if it's conditional, there's no probation, there's no you know, formal strings attached. And then there are dismissals after community supervision, which have different consequences for expunction and non-disclosure. We'll talk about that towards the end of the presentation.
And I'll just throw in a note with dismissals real quickly. You know, you will have to get a dismissal from most chief level prosecutors in the court. You know, every court will have several layers of prosecutor. You know, you have your 3, which is your brand new person in the court, your 2, which is your senior-ish person in the chief. And most dismissals will have to come from the chief in Harris County. What I'll say is just make their job as easy as possible. Give them evidence to rely on. The way that prosecutors get in trouble is they make tough decisions. And so for a lot of prosecutors, their defense mechanism is making no decisions, never get in trouble. And so if you can give them something that they can place in their file, something that they can document, hey, this warrants a dismissal, it will make them more comfortable in granting a dismissal. If you just go up and say, just dismiss it, you're not going to get results, almost guaranteed. And so just make their job easier, let them document their files, make it easy for them to make a, you know, potentially controversial decision.
Yeah, that's a great point. You know, we have a case pending right now, a felony aggravated assault in Harris County, where there happened to be a neutral witness who says that our client never ever touched a weapon. That's great. We have a sworn statement from that witness now, and that's our tool for trying to convince prosecutors to dismiss it before it makes it to the grand jury. So giving them the proper tools is incredibly important, because when someone comes back later and says, why did you do this? They need to be able to open their file and say, this is why. So your grand jury packet, and again, if this is something that comes up in your volunteer work, we are more than happy to share forms that we use for grand jury packets. So this is something we work really hard on every case. So because you are not allowed to be in the room, your packet is incredibly important. You're going to give a summary of your side of the story, your client's side of the story. Talk a little bit about who your client is. You know, she is a 52-year-old business owner, mom of 4, you know, whatever it happens to be. It's a chance to let the grand jury see your client as a human. You can put a picture of them with their family in the packet. You can talk about military service, whatever it is that really humanizes your client and makes them sympathetic to the grand jurors. You also can include virtually anything. We like to include relevant law as well as the description of the events. We like to include polygraphs. So there is no evidentiary rule to a grand jury packet. So you can have your client take a polygraph, and if they pass, you can put that in your packet. You can, if you have a victim, you can talk about anything you want with your victim. You know, let's say your victim has been arrested 3 times, but never convicted. Well, you know, at trial, that's probably not going to come out in your grand jury packet. You can say, you know, Mr. Smith is sees the backseat of a squad car regularly. You can do whatever you want. It's great. It really lets you present your side of the story the way a Law and Order defense attorney would get to. Sort of all bets are off. And other than showing your hand to the prosecutor, there's really no harm in it. The client gets true billed, they get true billed, you go on with the process, but you've at least afforded that extra opportunity to make the case go away quickly.
Yeah, and what I'll say about grand jury packets, if there is a greater than 1% chance that the case will not be indicted, then I would encourage you to prepare a grand jury packet. You know, I would say it's not very common. A prosecutor will take in 100 cases. If they have one grand jury packet, I mean, that's a lot. So they're not used to getting these things. It goes the extra mile. The downside, Emily already said it, you know, it does show your hand. It happens to work with what we do in self-defense cases, because we're not saying, you know, we're not saying, you know, they didn't do it. We're saying they did it and they're justified. So it doesn't really matter if we show our hand. So there are some cases where maybe that's not appropriate and you wouldn't want to tip them off. But if you have a case where it's you know, I didn't do it, or, you know, I did it, but I'm justified, especially in justified cases, and something that we do, making your client available to testify. You know, they can call in your client and ask them questions, humanize them. You know, the only person they hear from is prosecutor reading an offense report and sympathetic client. You know, that's a good opportunity to try to get a no bill. But assuming they get indicted, because most cases are.
Yes. Yeah, one thing we didn't mention, but I'll mention quickly, because the grand jury is a secret process, you're not going to find it on any court system about when your client's case is being presented. If you want to make your client available to testify or to present a packet, you're going to have to let the prosecutor know, and then they will coordinate with you on dates. Or else, if you do not alert them, the grand jury process will pass by without you ever have known. Okay, so the case got indicted, or maybe it was a misdemeanor case, so you didn't have a chance at the grand jury. Either way, you are looking at negotiating a good plea bargain for your client. So there are lots of criminal events. Criminal law generally in Texas is a big word salad of acronyms. So you're going to hear things that are confusing, like PTI and PTD. That's pretrial intervention, pretrial diversion. No one ever says them out to you. So it's PTI and PTD. This is a great tool. So generally, it's available to first-time offenders, people with no criminal history. You're going to want to, you're going to be required to present essentially information to the government to convince them that your client is a good candidate for a pretrial intervention. And what a pretrial intervention boils down to is a non-conviction probation. So they're going to be essentially reporting as a probationer. It's very, very similar. But it's an agreement between the prosecutor's office and the defendant. So the court system is essentially not involved in this agreement at all. You know, it used to be called a desk drawer probation, essentially, where a prosecutor might just take your file, not reset your case for 6 months, put it in the desk drawer, and just wait to see if you were behaving yourself. And then if you did, they would dismiss the case. Same idea, except much more formalized now. So essentially, be on your best behavior, satisfy the conditions of your pretrial intervention or pretrial diversion, and it is going to be dismissed. The case is pending the whole time, so you never enter a plea. It's great in part because as long as you don't bargain this away with the state, you're eligible for expunction after your successful completion of PTI or PTD, which is wonderful. We'll talk more about expunction later, but it's a great tool. It is common in Harris County for prosecutors to condition a PTI on not applying for expunction. So when your client says, when will this be off my record? Those are important considerations to take note of. Nothing is off your record in the state of Texas unless it is expunged or non-disclosed. So clients that have this idea, well, it happened 20 years ago, it's not my record anymore. Absolutely not. The only way to, clear a record is through these official legal mechanisms, and you can bargain that away in this case. Richard, do you want to discuss deferred?
Yeah, and so just familiarizing yourself with the different options that are available to you. Another important one is deferred adjudication, probation. What deferred adjudication is when your client would enter a plea of guilty or no contest, and the judge kind of holds on to the plea and holds it off to the side, and they don't find them guilty. And it feels a lot like a pretrial diversion, feels a lot like a straight probation. But so long as your client does everything they say they're going to do, the judge never enters a conviction in the case. Now, it's not the same as a dismissal. It's a not convicted. For some professional licenses, some licenses, it counts as a conviction, but for job applications, it won't count as a conviction. So it does keep your record cleaner. It's still going to be on your record. It's not eligible for expunction. It doesn't count, especially in the case of felonies, you don't want a felony conviction. So if you did a deferred on a felony and you successfully completed everything, you would not be a convicted felon. So there's a lot of upside to it. Now, there are some downsides to it. Deferred adjudication, supervision. You have all those same conditions, kind of similar like what we saw with the conditions of bond, don't commit any crimes, reside in the state of Texas, be subject to random urinalysis. The probation and the supervision is going to be tailored to your client. After they enter their plea, they're going to be evaluated to see how big of a risk they are reoffending, if they need to, complete their high school diploma, if they need to get a job. They're going to make all of those conditions of the supervision. And so long, and fines and things that go along with it. So long as they complete everything they're supposed to do, not convicted. Here's the big downside. If they screw up one of these things, the judge you've already pled, the judge is holding on to it. At that point, you are waiving your right to a jury trial. And now, if you screw up, you would have a contested hearing where the evidentiary standard is, 51%. Preponderance of the evidence. My brain fart. 51%, and they're not looking at 51%. Did you commit the original underlying offense? It's, did you break a new law? Did you test dirty on your urinalysis test? And so it's you don't get a jury. It's in front of a judge. These things are go very quickly, and the standards are very low, and the client is subject to the full range of punishment, which is a huge deal. I had a motion to revoke probation hearing on a deferred adjudication. The pretrial offer was 2 years TDCJ, prison. I was the prosecutor at the time, and I was begging the defense attorney, please take this new judge. We don't know what they're going to do. The hearing lasted all of 5 minutes, and the kid ended up getting 20 years. And even I, as a prosecutor, was like, that is not the right, that wasn't the right thing to do in that case. So they're kind of unwieldy, and you need to be careful so that there's that big hammer if they don't do everything they're supposed to do. Do you have anything to add to that, Em?
Only another positive side of deferred adjudication is the hilarious ways your client will mispronounce it. So keep a log of those. Deferred adjudication. No one can get it right. It's pretty funny. But yes, it is. The downside, the positive side of deferred, great, not a conviction on record. The downside, you will get the sense from your client whether or not they can successfully complete that deferred, if they are not responsible, if they are, really struggling with substance abuse issues, if, they don't have a lot of social support. I mean, whatever it happens to be, if you don't think they can successfully complete that deferred adjudication probation, do not agree to put them on it, because, as Richard said, they are then waiving their right to actually be tried on the underlying offense, and then they could be subject to the full range of punishment. So it's something to consider very carefully for clients who are a little bit unstable. Okay, so I'll talk about straight probation. So again, same mechanism essentially, right? You're going to do community supervision. You're going to be tested randomly. Your urine's going to be tested. You are going to have to complete all other, there's a ton of other hoops to jump through. You're going to have to meet with your probation officer once a month. Everything that we're talking about with the PTI and PTD, with deferred adjudication probation, except you're going to be convicted first and then go through this process. And it is, they are sentenced. They're sentenced to jail or prison time. The sentence is then probated. So that is one of those things. If you have a client that you're a little bit worried about, let's say that your client committed a third-degree felony. So the range of punishment is 2 to 10 years in prison. And the judge is going to accept the plea, sentence them to 5 years, probated for 3, which is, if they then do not complete that probation over the 3 years, they screw up in whatever way, they pick up a new case, whatever it happens to be, the maximum time they could spend in prison is 5 years rather than 10, which would be the maximum under, which is the maximum punishment. So it does count spend in prison if they don't successfully complete that probation, which is good. Of course, the downside is you are convicted, you plead guilty, and you're found guilty. It is on your record forever. There's no expunction or non-disclosure. The only way to set yourself right would be to apply for a pardon. And, unless you're best friends with Greg Abbott, it's not going to happen.
Yeah, you see
Richard,
pardons.
Anything to add?
Yeah, pardons are granted when, they knew evidence or they misapplied the law, and probably not in your case. So, I mean, that comes up so rarely. Talking about just different ranges of punishment, I won't read all of these off, but there are a few things that you're required to inform your client of. One of the most important things is the potential range of punishment. They need to know what they're facing, and it scares a lot of clients when you go over these things. In Texas, Texas is kind of unique. Juries assess punishments here in Texas, and they give them an incredible range. So, Class B misdemeanor, Class A, a year and lower. Class B, up to 6 months in the county jail. Class C, fine only up to $500. That's not on here. There are some disadvantages and some things that you wouldn't necessarily know off the top of your head if you had not done this before. You're always going to want to be seeking reductions. You want things resolved as misdemeanors if they can be resolved, if your client is guilty. State jail felonies, that's kind of a double-edged sword. It sounds, not so bad. It's not enhanceable for, purposes of being 25 to life. There's some advantages to it. The downside is state jail felony, they have terrible facilities. Some of your frequent flyers, they don't want to go to state jail because they don't have sufficient rec rooms. They spend day for day instead of, in TDCJ, they get 2 for 1, or they get paroled even faster if it's a drug conviction or something like that. So some people will prefer to go to prison if you can believe that. So just know the ranges of punishment. Make sure you inform your clients of what they're subject to. If you're representing somebody pro bono, somebody who's never been in trouble before, these are not how cases are resolved. Somebody doesn't get charged with their first degree felony and get life. I'm sure, or maybe it does happen. I bet you it's pretty rare. Same thing goes for misdemeanors. First time somebody's in trouble, charged with a misdemeanor, the chances that the state, seeks the maximum, well, the only way to handle that is to try the case, because what are the chances the jury's going to give them the maximum? So just know the ranges of punishment and inform your clients.
Yeah, and I would add, particularly if you're looking at a felony offense and they're offering prison time, definitely seek out a criminal defense attorney, email us. There are lots of considerations that are not something that you can look up in the code. We've got listed here, county jail. Harris County oftentimes is 3 for 1, which means for every 1 day you serve, you get 3 days of credit. So you're not spending that long there. Also, a lot of times people want to serve their time in the county jail because this is where their families are. State jail and TDC, you get shipped out anywhere throughout the state. So you're not going to have an opportunity to visit with your family. Like Richard said, state jail facilities are terrible, but at the same time, prosecutors are often going to give you a choice. They'll say, 2 years in TDC on that 3rd degree felony, or I'll reduce it to a state jail for this much time. And you need to be able to talk to your client about, well, this is what the facilities are like in each place. This is how, taking a pen trip, right? Going to TDCJ, even if you're only processing it out in a couple of months because it's a drug charge, you're paroled out on quarter time. There are, the consequences of taking a pen. 1240, right? So 1244A is another, that's the actual code section that allows for a state jail felony to be punished with county jail time. So there are, if you have taken on a case and you're not a, regularly practicing criminal practitioner, and they're offering you jail time or prison time, definitely reach out to the defense community, because these are just not things you can look up in a book. So, and they are important to help your client make a decision. Reductions, Richard mentioned earlier. So the state is not going to negotiate with itself. And if they are unwilling to dismiss your case, a lot of times you can get them to reduce it. But you've got to ask. You don't get it if you don't ask. There are all sorts of creative ways you can have a case reduced. You always want to try to get it reduced down to a misdemeanor when you can. You can add in an attempt. Anytime you make something inchoate, you're going to notch the punishment range down one level. So, an attempted Class A misdemeanor is going to be punishable as a Class B misdemeanor. It's a great tool, but it's as limitless as your imagination, essentially, what you can get cases reduced to.
Yeah, the elements of, you can turn almost any crime into something else. There's so many overlaps with the different elements. We had an attorney message us a week ago saying, I got a guy charged with this. Do y'all have any ideas of what else they could be charged with? And we were able, you just got to be creative. We came up with 5 or 6 different things that would overlap and meet the same elements of the offense. So be creative, reach out to the defense community. You probably don't need to reinvent the wheel. A lot of these things have already been kind of filled out, and so but you have to be creative. All right, you want me to talk about collateral consequences?
I do.
Okay. All right, collateral consequences. Outside of a conviction, there are so many things that goes into being convicted of a crime, whether it's a misdemeanor or a felony. So there are a lot of outside considerations, outside of what you read in the judgment paperwork. If you were to enter into a plea, or if your client were to be convicted at a jury trial, if you're reading the judgment of conviction, if that's all you relied on, you wouldn't be giving your client good legal advice, because there's a lot of things outside of the judgment which they need to be aware of. One that comes up frequently with us, this is an example, in the United States, if you have a crime where there's an element of force or attempted force, and it's directed at a family member, former spouse, somebody you cohabitate with, family member, domestic violence is what they call it. If those 2 elements exist in that crime, if the person has a conviction for that, they would be prohibited from possessing firearms or ammunition for the rest of their life. And that's a huge, huge consequence. Also, if the person was at an apartment whenever the alleged offense took place, if they were evicted, if that's on their record, hey, this person was evicted because they were accused of a crime, they were convicted of the crime, that might limit their possibility of getting safe, affordable housing. Do you have a story about that, Em?
Oh, yeah. Oh, I do want to jump in. A felony conviction will almost always prohibit someone from renting in the future. Once the background check once any apartment management complex does a background check, sees any felony conviction, they are not going to rent to that person, which is a really big deal. And it is, it's incredibly limiting. So that's something that people don't often think about is, people think about, how am I going to get a job with this on my record? But they don't often think about, how am I going to find a place to live with this on the record? And that is a big problem.
Yeah, another big one that you have to be aware of, and you can't plead ignorance on this, is immigration consequences. We have some guidance that, just telling your client, hey, you need to consult with an immigration lawyer, that's not effective. You have to take you have to take more action than that for them to figure out the immigration consequences for a conviction. If somebody is here legally, or if they're not legally present, if they have a conviction, they could be barred for reentry for life. They could be denied, if they wanted to naturalize or immigrate for life, they could be barred reentry for decades. This stuff I would not play fast and loose if you have a client that is not an American citizen. There are so many consequences attached to that. Another one, a loss of professional trade licenses. Doctors, lawyers, if we get in trouble with certain crimes, we can lose our licenses. The same applies to hairdressers and electricians. So if your client is in the trades, you need to be aware of those issues. I have a link here in this slideshow, I believe is going to be distributed, this National Inventory of Collateral Consequences. It doesn't just have Texas, it has every state in the United States. You can look up, conviction for this, and it clearly organizes, hey, here are all the potential consequences outside of conviction, so that you can properly advise your client. If they're going to, when they enter a plea, if they were to enter a plea, it needs to be done freely, voluntarily. They need to be informed, and part of that is figuring out the collateral consequences. All right, Em, you want to talk about discovery?
Okay. I'll talk about discovery. Discovery in criminal matters is completely different than what, if you practice mostly civil work, completely, totally, utterly different. Essentially you have as your first piece of evidence that you're going to get from the state, your offense report. So that's your officer's report of everything that happened. Any officer who actually arrives on scene and does something should write a supplement. That's your really first big piece of evidence. It is not admissible in trial. It's hearsay, but it is going to give you a heads up about what is going to come in at trial. And if the state hasn't disclosed something to you, it's going to provide you with the information you need to know what to ask for. Now, what you are going to see that is going to be your primary evidence, your 911 calls, dash cam footage, right? That's your squad car, in-car cameras, body cam footage if those officers are required to wear body cameras, any statements from witnesses or victims, and you'll have their information in the offense report, crime scene photos, whatever scientific evidence is applicable, whether it be DNA, gunshot residue, blood alcohol contents, whatever it is that happens to apply to your case will be disclosed to you through discovery. But discovery is not bilateral. So you get everything from the state. If your client brings you a piece of evidence, if it's exculpatory, by all means, give to the prosecutor, try to get them to dismiss it, but you are under no obligation to share that information. And in fact, if it was not favorable to client, you should, if you like having your license and your bar card, you should not share that with the state. Richard, do you want to talk about Brady and Morton, just how that goes?
Sure. Yeah, and just to add a note to that, you shouldn't be taking, evidence from your clients. The State Bar has given us some guidance on that recently. They should keep possession of evidence. Brady and Morton, we have federal and state case law talking about, we have different levels of duty, imposed by the United States Constitution, the Texas Constitution, Texas Code of Criminal Procedure, and then even the Texas rules of professional responsibility. So we have all of these different rules and duties that attach at different levels. I will just, give you enough to be dangerous if you're representing somebody on a criminal case. You need to familiarize yourself with Code of Criminal Procedure 3914. That's a codified version of the Michael Morton Act. And essentially, the state needs to be giving you all the evidence. If you read the TDCAA, the Professional Organization for Prosecutors, their tone has changed over the years from, super hard advocacy, push your case forward to, if you look at it decades later, nowadays, it's just give it over to the defense. Just give it to the defense. And so for the most part, prosecutors are on board with this. There are still some, unfortunately, there's still some people who will, not let you know a witness is unavailable. That might change your decision to go to trial or not. I think that's the kind of stuff that needs to be disclosed. But familiarize yourself with 3914. Like Emily said, discovery doesn't go both ways. Don't take physical possession of evidence from your client. And you have anything to add to that, Em?
Oh yeah, a couple things. So 3914, when you read it, you'll see it lists, essentially it's telling you that you're not entitled to just exculpatory evidence, which is what Brady tells you, but you are entitled to everything except attorney work product and investigator work product. Technically, you're entitled to that upon written request. Now, practically, I don't know of any county around here who actually mandates the written request come through before they start sharing discovery. It is still a good practice for later down the road in case you're grieved, in case something comes up. So we actually, we've listed that in our motion practice that we'll talk about in a few minutes here. And you can always email us for a form Michael Morton request. Good practice, generally not practically necessary before you start receiving discovery. Sharing discovery with your client, it is tightly controlled for criminal discovery. You cannot share electronically, so you can't email them a copy of the dash cam footage to watch. You can't make photocopies and give them out to your client. It is good old-fashioned, come into my office, sit down with the file. You're under an obligation to redact personal information of victims and witnesses before you show the client. but then the client can view in your presence only, and you cannot actually give anything to them to keep. Okay, so trial issues. Again, if the only thing you've done thus far in your career or your primary practice has been civil work, this is incredibly, this will be news. So your client will generally ask, what about a speedy trial? What about a speedy trial? Because a year and a half into the process, when they haven't gone to trial yet, they're not going to be happy about that. They're on bonds. They're paying into the system every month. They can't get a job because they've got a case pending. There are all sorts of reasons why they want to speed up the wheels of justice. Unfortunately, as Richard likes to say, the wheels of justice turn soul-crushingly slowly. So, if you are 50th on the trial docket and your client says, file a speedy trial motion, I want to go to trial, on this day, it's just, unless your client's been sitting in jail for 8 years without a trial, the speedy trial motion is not going to get you anywhere. Now, on the flip side, right, it's hard to speed it up. And in fact, it's not good generally for the defense to speed it up. Cases get worse for the state over time. Officers get in trouble or they retire and move out of state. Witnesses die or become unavailable. Evidence gets lost or destroyed. There's all sorts of things that happen that, you can try to tell your client. Of course, we try all the time. They don't always want to hear it because they want to get this over with. But the case generally gets worse for the state and better for the defense the longer it lingers. Now, that being said, right, it's hard to speed things up and you probably don't want to speed things up. But if you are first on the trial docket, second on the trial docket, maybe even, Richard, what do you think, top 5 or 10?
Yeah.
Top 10.
I'd say top 10, you need to be ready.
You need to be ready. It's not a, I've seen civil litigators. I'm related to several, they walk into the courthouse. They're the only case set for trial and they just are going to go get a continuance. No big deal. Does not work that way in criminal court. The judge does not care. If you are up on the docket, you should be ready to go. Don't count on a continuance. You are often given your first continuance, but that's going to be about it, unless there's a witness missing or something that really prevents you from going to trial. Richard, do you want to pick up here?
Yeah, sure. And so, you're going to have lots of resets, lots of, negotiating before you get to trial. And we don't have the time to go over how to try a case extensively. And if you find yourself in that position, you need to get yourself up to speed on what to expect in trial, how to effectively advocate. You need to dedicate some serious time to that. So we can't go over how to try a case from beginning to end, but you just need to know these cases, criminal cases, once you are in the strike zone, once you are there, these things are very, very fast and loose. There aren't depositions. There's no sworn testimony from witnesses. Admissibility of evidence is determined at trial. And so you need to really, when you're saying you're ready to go to trial, you need to be ready to go to trial. Have already interviewed your witnesses, have already defense theory prepared. At that point, I work backwards. I say, what does my ideal jury charge look like? And I work my way backwards. But just know that the criminal trials, once they are in that zone where you're going, the system will just railroad you and march over you, and the case is going to go to trial. So just prepare yourself for that.
Okay. So
you want me to go over these?
Sure.
Okay. Well, because we're going to speed up, I want to leave some time for Q&A. So motions practice, again, at the end of this, we're going to share our email. If you need boilerplate motions for any of these things, you're taking your first criminal case, you have questions, we'll absolutely share those things for you. These are kind of the minimum motions I would expect to see in any criminal file. A request for discovery and evidence, the state shall produce that as soon as practicable. If upon request, disclosure of exculpatory mitigating evidence, those are Brady and Morton motions, are motions under our Code of Criminal Procedure 3914. Request for notice of expert witnesses. You have to do that 30 days before trial. If you do it early in the process, get it out of the way. Notice of extraneous crimes or bad acts. In your criminal trial, it's really two trials. Your first trial is black and white photograph. Did they do it? Did they not do it? And then the second trial is, all right, it's a photo album. What is this person? What is their life? What is their criminal history? How do they need to be punished? And so for that first trial of did they do it? Did they not do it? Typically, they can't bring in previous other crimes or bad acts. And if they want to, they need to give you notice of it so that you can prepare adequately for trial. So make sure to ask for those 609 rules of evidence issues. Motions to suppress, that can be boilerplate. Did the cops violate your person's right? Was it pretextual stop? Did they make an arrest without, or did they make a detention without reasonable suspicion? If you have a suppression issue, you'll see that in a lot of cases, especially for traffic stops. And then your notice of expert witnesses, you have to deliver that once the state asks for it. You got to give it to them within 20 days before trial. So there's a couple of deadlines associated with these things. You want to add anything to that, Em?
Yeah, only that Richard, when we were discussing this yesterday, made a great point, which is if you get everything filed 60 days in advance of trial, you were in the clear. There are a couple deadlines that are pretty far out. If you are, I don't think that you're going to take on a pro bono, super ag sex assault of a child. But if you did, there are some, motions that have to be filed 60 days out. When things get more complex, deadlines push out. All these standard motions are easy, fast. Here is a motion timing issue, which is your 2801 hearing. So if the court sets a pretrial hearing, you have to have your motions filed 10 days before said hearing. Again, if you file all your stuff further out, 30 days out, 60 days out, you do not have to worry about it. But do know that if you, if you have a motion to suppress, to discuss, you need to be ready to file that before this hearing. Now, if you are unclear as to whether your setting is a 2801 setting, you can ask your court coordinator. They will let you know exactly what's going on. But if it is set for pretrial hearing, you have to set those, file those motions.
And the same system you use to file, your civil documents, that's the same system you use for criminal. Most deadlines, expert witnesses, like I said, 30 days. If the state wants to consolidate offenses, they have to let you know 30 days. If you have confessions, if they plan on using a confession, they have to tell you 20 days in advance. If you plan on pleading insanity, you have to give them heads up 20 days. Business records and outcry notices, 14 days. And then if they want to amend the indictment, this is the last one that I'll say that's really important. If they want to change the indictment language, they have to give you 10 days notice. If they do it any time before that, you need to move for a continuance. It is almost per se ineffective assistance if you do not ask for more time when they change the language in the indictment or the information if it's a misdemeanor. So that 10-day, if they want to amend it, 10 days or less, you need to move for a continuance.
Yeah, do not waive your 10-day notice on the indictment. Okay, practical trial considerations. Briefly, in Texas, you can choose judge or jury punishment, and you have to file that election ahead of time. So you can't wait and see if you've got a friendly-looking jury before you make a decision. It's got to be filed before jury selection begins. Just as a practical rule of thumb, most criminal defense attorneys will tell you if you're trying a misdemeanor case, you should select judge punishment. Felony cases, you should select jury punishment. That's especially important if you are trying what we call a 3G case, which is just the subsection in the code where your violent offenses live. Because in a 3G case, a judge cannot give your defendant probation. Only a jury can do that. So again, consult with criminal defense attorneys locally. If you don't do this, generally they can talk to you about what your judge generally does for punishment in that court. They'll help you through what election to make. Ultimately, it's up to your client, but it is you can guide them the right way. You need to file a motion that your client is eligible for probation. They've got to swear they've never been convicted of a felony. If they're not eligible for probation, they're not eligible for probation. But if they are, you've got to file a motion before trial begins. Know your technology. We are still bouncing back and forth between courthouses, although we're not trying cases right now because of COVID, but Before that began, there was still a lot of bounce back and forth. In fact, we tried a case fairly recently where we switched courthouses halfway through trial from the civil to the criminal. The technology is completely different, courthouse to courthouse and courtroom to courtroom. So know what's going on before you begin trial, in terms of what cords you need, just things of that nature. Felony offenses, if you're trying a felony case, you need to warn your client that it is entirely possible they will be taken into custody upon conviction, and they will be spending the night in jail until punishment is over. You can get bonds set up so they do not have to go into custody. If your jury comes back guilty at 7 o'clock at night, there's not going to be anyone there to process that. You've got to send them into custody. So they need to be ready to write down phone numbers because they're stripped of their phone. It's done. All bets are off. So that's something that you need to be ready to work. Okay, Richard.
Yeah, let's talk about expunctions and non-disclosures. So expunctions are a complete destruction of all records related to an arrest. And so these come up really in very few scenarios. If the case is let's say the case is declined and the statute of limitations is run, if the case is dismissed without entering any kind of plea and the statute of limitations is run, or upon acquittal by a jury or judge, that's when you would be eligible for an expunction. You'll have a lot of clients say, hey, I got that expunged, or, oh, hey, can you help me expunge this? Unless they fall into one of those three categories, they're not going to be eligible for an expunction. But assuming that they are, it's not too difficult of a procedure. But essentially, you put all the agencies that had their hands on a case on notice. Hey, I want you to destroy all your records. They get a chance to object to these things. So long as you're qualified, there shouldn't be any roadblock to this stuff where you start running into problems. And when district attorney's offices start objecting to these things is when statute of limitations have to run. Most of the time, that's where you'll find your issues. So if your limit is run, it shouldn't be too big of an issue. But essentially, they destroy all the records. And upon an expunction, your client can legally deny having ever been arrested unless testifying in a criminal case, in which case the only thing they have to say is that matter is expunged. That's the only way that they have to respond under oath in a criminal trial. Otherwise, they could say, I've never been arrested. They can say that on employment applications. They can say that to anybody. So there's a lot of advantages to expunctions. Non-disclosures, we see this is less common, or I think it's becoming less common for clients who have received not a conviction, but some kind of dismissal on a plea or on a deferred adjudication. They may have their record non-disclosed, which means it's just a sealing of the records to where they would not be accessible to the public. It's a very similar procedure to expunctions. Why this is kind of not as popular anymore is because we have all these mugshot websites, things are posted online, people post things on social media. It makes it very difficult to kind of contain, once the cat's out of the bag, it's kind of hard to contain these things. But if a potential employer wanted to run your background check, the government agency would say, they wouldn't respond to that inquiry. Government agencies can still communicate with, if you're going to get a license to carry a handgun, for example, they would still know about it. So government agencies, police officers, courts, they're still going to know about the record of arrest and prosecution, but potential employers, the public wouldn't know. So there's some advantages to it, but it's, like I said, it's kind of not as popular as it used to be. You have anything to add to that, Nick?
No, just, this is, that question you're going to get, how long will this be on my record? These are your answers, because the answer is, if it's a conviction, forever, but something less than a conviction, these are your options to clean your record. Non-disclosure is really, like Richard said, it's almost useless at this point. But expunction really is great. In fact, when I interned at the Harris County DA's office, I interned in that department, and we actually went through when an expunction was granted and made sure that everything was wiped, that we had no access to it. So it's a great tool if you can get it, but that's really the only way that your client's record. Okay, we're getting close to the end here. So practical steps before you take your first pro bono criminal case. Remember, we were talking about SPIN numbers for inmates. Congratulations, lawyers get SPIN numbers too. You can go to the county clerk's office, apply for one. They'll get it to you real fast. They essentially only need your bar card. They will assign you a SPIN. You have to have one before you sign on to your first criminal case, because that is how Harris County identifies you. I recommend applying for a frequent courthouse visitors badge. You can do that through the Harris County Administration. If you drive downtown during, the morning of any weekday and you see those lines stretching around, snaking through the streets and around the buildings, those are the lines to get into the criminal courthouse. You do not want to be in that line. Not only is it unpleasant, but now, we have extra considerations because you don't want to be necessarily exposed to the COVIDs for that long. So the criminal courthouse is still up, running, functional, and you want to limit your exposure. Get that courthouse visitor's badge. You do not have to process through security, and you don't have to wait in lines. It's much, much better. Document the scope of your representation. So you're taking on this matter pro bono. Are you going to do a retrial if there's a mistrial? Are you going to handle the appeals? Who's going to pay for an expert witness? Who's going to pay for a polygraph if you want one for the grand jury packet? Are you going to handle any collateral cases? So I'll give you an example, and then I'll turn this over to Richard. I've got a client who was arrested for aggravated assault at her apartment complex. She's being evicted. That's something that I'm agreeing to handle for her, but that's definitely something you want to lay out, because when you don't show up for the eviction proceeding, you don't want to be grieved for that and not have a leg to stand on. Richard, do you want to talk about Hunter quickly?
Yeah, and even when you do get your agreements in writing, sometimes it's a blurry line. We represented essentially a pro bono case on a self-defense case. Clean shoot, declined. Nothing to see there. But then wrongful death suit came, and then foreclosure came on property, and the thing is just the gift that won't stop giving. So make sure to document the scope of your representation very well. And even when you do, you can still run into issues, but you don't want to. You want to set the expectation, because where people and clients get frustrated is, what you expect and what they expect are different, and that's where they get mad. When the expectations are different. When y'all are on the same page of what the scope of representation is, it really makes for a better attorney-client relationship.
Yeah, and document your communications that you have verbally. Most criminal clients are lovely, wonderful people. There's good in everyone, particularly if you're taking the matter on pro bono. You're doing it because it's the right thing to do, and that person deserves the help. However, there are often times where 5 years have gone by from a conviction. That conviction they took was the best deal you ever could have gotten them, kept them out of prison, maybe they just had to be on probation, whatever it happens to be. Down the road, that conviction is sitting well with them. They're going to file a grievance against you and say that you coerced the plea, or you didn't do this or that. Make sure that if you have a conversation with them, follow it up with an email, just keep everything tightly documented. Again, you hope that you don't have to worry about the grievance process later. But I think that it's criminal cases and family cases are the most grieved. So just make sure you're documenting. Okay, these are great resources for there's forums, listservs, reach out to anyone involved in Texas Criminal Defense Lawyers, Harris County. The National Association is great. Email us, questions@walkertaylorlaw.com. Anything you need, practical questions, motion banks, we are more than happy to help out anyone helping the community. So let's know, Richard, do you have any, before we open up, do you have any follow-up?
No, I would just say, it's a good opportunity. It's the right thing to do. And I'll repeat what Emily says all the time. The government's a bully. They need good people standing up for people for the right reasons. And so that's why we really encourage y'all to take on these cases. But we got just a couple of minutes left, Allie. I don't know if you can do a question and answer. Is Allie there?
I'm here. Sorry. I was thinking. Well, we have 5 minutes. I think if people have any questions, we can knock it out in the next 5, and any we have left, we can just go ahead and refer to your email if y'all don't mind.
Perfect.
I'm going to mute myself, and I guess Emily, just unmute whoever. If you switch over to gallery view, you should see everyone. Whoever, I guess, like Ben said, raises their hand, I guess. Or just starts to talk.
I have a quick question.
Yeah, Justin, go ahead.
So, for the bond forfeiture, you cannot appear on behalf of your clients on any cases?
So on the bond forfeiture, so what you're saying is your client isn't there, the judge is trying to determine whether or not, to forfeit their bond. Most judges will not want to have the hearing unless your client is present.
I see.
I think he's asking if you have to have the client present at every setting.
Oh, okay.
Yeah, something like, if you have to go to the first, I think I understand you need to go to the first, I guess, adjudication, but then after that, having them, come every time.
Yeah, so check with the court. It used to be before this last election that there was client every time. If they're not there, the bond is forfeited. There are some misdemeanor judges now. Andrew Wright is one. There's several others who actually don't require your client to be there every time, but that is the rarest of the rare. If it applies, you'll know. The coordinator should tell you. Now with the coronavirus, we have some alteration in that as well. For example, there's some courts that'll require them to be there the first time. Every other time they can appear by Zoom. So generally speaking, the rule is they have to be there every time. It's going to be a coronavirus or one of those very, very defendant-friendly misdemeanor judges in Harris County who bend that rule.
Thank you.
Any other questions?
Okay, I have one more then.
All right.
So when you went for the declined process of how it's resolved, is that a motion practice? Do you put a motion, or is that just some kind of, you work that out with the prosecutor?
So you'll work it out with the prosecutor. It is a motion that originates from the district attorney's office. Depending on your county, Harris County, they will file a letter in the case file, because at the same time your client is arrested, they'll file a complaint information, just as a placeholder until indictment if it's a felony, or they'll, information if it's a misdemeanor. If they decline to prosecute, if they file that information right away, then they'll have to file a dismissal in order to resolve it. So that's what you'll see in Harris County. In felony cases where they just have a placeholder as a complaint, you might get a letter saying, this case is declined. In smaller counties where those aren't screened by DAs on the front end, you'll see a lot of decline letters filed into cases, but that will originate from the district attorney's office. That's not something that you would need to prepare.
Yeah, so it's just good old-fashioned call them up, beg plea, and then hopefully they will file the motion.
Okay. And that was it, I promise.
All right, well, if anybody else has any additional questions, please email us at questions@walkertaylorlaw.com. We'd be happy to talk to y'all. I mean, there's a lot of practical things that you just want somebody to talk through with you. Please, we'd be happy to make ourselves available as a resource and be happy to talk to you.
Yeah, and one of the most difficult things that comes up is strategy, because again, that's something you can't look through the code to find. So always you want to just, talk about, strategy, give us a shout.
Thank you guys so much for coming and talking with us. I think for me, who did that for a couple of years, that was really informative. So I know that we really appreciate it.
All right. Thanks
Thank
for
you,
having
Allie.
us.